Well, thank you everyone for joining us today. This is our first webinar for 2021, and it's on patent eligibility of software inventions and diagnostic methods in Canada. My name is Hetal Kushwaha. I'm a partner in the Ottawa office of Marks & Clerk, and I'll be moderating today's session. And Marks & Clerk is a leading provider of IP services worldwide. We have 18 offices globally. And in Canada, we are celebrating our 100 years of operation. Just a couple of housekeeping matters. I know we're probably all very familiar with the Zoom setup by now, but just a quick refresher. Attendees, you are all in listen-only mode, and the event is being recorded. In the event of technical issues, you can refresh your page, and if that doesn't work, you can contact IT@marks-clerk.ca for assistance. And everyone will be muted. If you do have a question, there is a Q&A box if you hover down at the bottom toolbar, and you can submit a question that way. And we'll do Q&A at the end of the webinar. So I'm very delighted to introduce our speakers, my partners, James and Jonathan. James is a partner and registered Canadian patent agent of Marks & Clerk Canada. James has almost 20 years of experience practicing in the area of patent drafting and prosecution, with an emphasis in the fields of life science, pharmaceuticals, oil and gas, polymers, organic and inorganic chemistry, as well as chemical engineering and mechanical engineering. And Jonathan Pollock is a partner in the Toronto office of Marks & Clerk Canada, and he is a registered Canadian patent agent. He specializes in patent drafting, prosecution, and opinion work in primarily the electrical, computer, telecommunications, and mechanical disciplines. Jonathan helps his clients navigate the global patent system and works closely with them to develop practical patent strategies for their businesses. And with that, I will pass over the presentation to Jonathan.
Hi, everybody. I seem to be having a little bit of a lag, so hopefully you can all hear me clearly. I'm just going to start sharing my screen here. And so I'm going to start with a brief history, but before I do that, I'm just going to have the usual Zoom caveat that we may be interrupted by children or barking dogs. I hope to keep that to a minimum, but that seems to be the Zoom usual these days. Now, when I say brief history of patent eligible cases in Canada, I'm not saying that to leave out cases, but really there just haven't been that many. The first case that related to patent eligibility specifically for computer implemented inventions was the Schlumberger case back in 1981. In this case, the patent application disclosed a process whereby measurements were obtained in boreholes and they were recorded on magnetic tapes, transmitted to a computer, and converted by the computer into useful information produced in human readable form. The courts found that what was new in this discovery was the calculations and the mathematical formula used in making those calculations. The courts then determined that the subject matter of this was not patent eligible subject matter, and the use of the computer didn't add to that patent eligibility. Quick example of the claim is claim 1 that's shown here, and it really just relates to machine operated method of processing well logging data. So it's just processing the data, and it just has the steps of deriving measurements and machine combining a bunch of different measurements to arrive at an output parameter representative of at least one formation characteristic. The next case I do want to talk about is the Free Will Trust versus Electrosante in 2000. This is a Supreme Court of Canada decision. It's one of two that were released that were decided in 2000. These decisions are not specific to patent eligibility, but they are important to the construction of the claims, and specifically in Free Will Trust talks about how to define essential and non-essential elements of the claims, and these will be important as will be discussed later. Specifically, Free Will Trust says that for an element to be considered non-essential and thus substitutable, it must be shown that it was clearly not intended by the inventor to be essential, or that a person skilled in the art would appreciate that that element could be substituted without affecting the working of the invention. Shortly afterwards, in around early 2000s, the Patent Office seemed to introduce a technical effect test. There was no real basis for this. It seemed to be a policy shift at the office. And what happened was claimed features that were not considered to have a technical effect were simply discarded from the claim, and then patent eligibility was assessed on the basis of the remaining features. For those familiar with European practice, it may sound similar, but it was quite different. This test basically stood until the Amazon decision in 2011 by the Federal Court of Appeals, which said that it's not clear what was meant by technological, nor could the courts understand why the commissioner thought that a one-click method of internet shopping, which seems to be technological, could not be considered technological in nature. The court also identified that, also said that the identification of the actual invention should be granted in a purposive construction of the patent claims. So in response to this decision, the Patent Office implemented a post-Amazon practice notice, which directed examiners to construe the claims, identify the problem faced by the inventors, identify the solution, and then any claim features that were not essential to solving the problem were considered to be context and discarded from the claims. Anybody who has been anybody who's been prosecuting applications in Canada in the last 10 or so years is familiar with the problems that was introduced by this problem solution approach. Basically, the Patent Office had almost free license to define the problem however they wished, and almost did so to exclude features that they didn't want to have included in the solution. So it almost felt like it was an arbitrary, or at least a very subjective test by the examiners, and they could define things how they wished to include or exclude elements. And it became a very difficult argument to counter, because we got into a lot of the Patent Office saying this is the problem, and the applicants coming back and saying no, this is the problem, and there was no real support to counter the Patent Office's position. Of course, this is what led to the recent Shui decision that was released. It was decided in August of last year. Shui appealed to the courts from the Patent Appeal Board decision on two bases. The first one was that this problem solution approach does not meet the claim construction set out in the Supreme Court of Canada decisions in Free Will Trust and Whirlpool. And the other reason for the appeal was that the Patent Appeal Board failed to adequately address their submission that the claims actually were related to technical improvement to the operation of a computer. The court ruled on the first ground of appeal and concluded that the post-Amazon guidelines do not actually direct the examiners to follow the proper tests set out by the Supreme Court of Canada. Rather, the office was directing the examiners to use the problem solution approach, which was akin to the substance of the invention that was actually discredited in those Supreme Court of Canada decisions. So the court set aside the commissioner's decision and sent the application back to the office to reassess the amended claims with the Supreme Court of Canada's test for claim construction. Although the courts did not rule on the second ground of appeal, the court did request that the commissioner adequately address the Shui allegation that they did actually relate to a technical invention. So this led to the post-Shui guidance, and I apologize, it's a bit dense, but I wanted to try and make sure I got through everything that was actually in there. So the guidance was released in November 2020, and it has a couple of key elements. The first one is that all the elements in a claim are presumed to be essential unless it is established otherwise or is contrary to the language of the claim. So this is a very good start compared to what the Patent Office was doing previously. They also go on to say that an identification of an actual invention is grounded in a purposive construction of the claim, and an actual invention may consist of either a single element that provides a solution to a problem or a combination of elements that cooperate together to provide a solution to a problem. An actual invention that includes a disembodied idea is not patentable unless it is part of a combination of elements that do cooperate together and have a physical existence or manifest discernible effect or change. And they also go on to say that an element may thus be an essential element of the claim because the applicant intended it to be essential, even though it has no material effect on the working of the invention, and that such an element would not form part of the actual invention because the fact that it has no material effect on the working of the invention means that it does not cooperate with other elements of the claimed invention. These last two points I'm a little bit confused on, to be quite honest with you. It will be interesting to see how the Patent Office does implement this but it's interesting to see how and claim element can be part of an essential part of the element, but may actually not be part of the actual invention. And so how does the Patent Office apply this to computer implemented inventions, which is what I'm really talking about? There's some interesting notes in the guidance for computer implemented inventions. Firstly, it is insufficient that a computer is identified as an essential element of claimed invention. So as I mentioned on the previous slide, the fact that the computer is essential to the invention doesn't necessarily mean it's essential to the actual invention. And I think that's going to lead to some interesting discussions with the Patent Office. It is also insufficient that the computer is necessary to put a disembodied idea into practice. So oftentimes, if you have an invention that relates to something that only has presence in a computer, so a virtual wallet or a virtual currency, it is clear that that currency needs the computer to be put into practice. However, the Patent Office is saying here that the fact that the computer is necessary doesn't afford the claim's patent eligible status. Rather, it is necessary to consider whether the computer cooperates with other elements that the combination has physical existence or manifests a discernible effect or change. So those are the key features for computer implemented inventions. If the claims are directed to an algorithm, it's not sufficient to simply process an algorithm on a computer in a well-known manner. So simply having inputs and outputs, like displaying information on a screen or reading something in as an input, is not sufficient to make the computer essential to the operation of the algorithm. If the algorithm is then considered by itself to be the actual invention, the subject matter is not considered to be patent eligible. Rather, it's necessary to conclude that the running of the algorithm on the computer improves the functioning of the computer. And this is some interesting language because it's uncertain what that means. We'll see from the examples that I'm going to discuss after this, there is some guidance, but functioning of the computer is fairly broad terminology, and it'll be interesting to see what the Patent Office considers to be something that will improve the functioning of the computer. And lastly, with regards to business methods, a business method must cooperate with the other elements of the claimed invention to make up an actual invention that relates to the manual or productive arts and has a physical existence. So this is similar to basically the computer, where the business method can be an essential element in a patent eligible invention, but there must be something that provides some sort of physical existence or manifests a discernible effect or change. So moving on to the examples, I'm going to just discuss 3 of the examples because I think they give a good idea as to where the Patent Office is coming from. I'm going to start with example 3, which relates to a computer implemented method of analyzing data from seismic measurements. And it comprises 3 steps: receiving the data, processing the data, and then displaying the results. In the examples, the Patent Office says that from the claim itself and confirmed by reference to the rest of the specification, steps A and C are really just generic input-output steps of a computer-implemented process. So there's nothing there to suggest that receiving the data or displaying the data is done in any other way other than a standard computer-implemented process. So what is left is to determine whether step B, if the computer forms part of the actual invention as disclosed in step B. And there are 2 tests that the example used. The first is to determine whether the algorithm recited in step B is solves a computer problem. And in this particular example, it suggested that there's no evidence that this algorithm actually solves a computer problem. The next test is to see if this algorithm also reduces the resources used in the computer processing. And once again, the example suggests that there's no indication that this algorithm actually reduces the resources used in the computer processing. So as a result of this, the actual invention is considered to be the algorithm and has no physical existence, and the claim is considered to be patent eligible. One thing I do want to point out here that seems a bit interesting to me is the fact that there are 2 tests for determining whether the computer forms part of the actual invention. The first one is whether it's a computer problem, and then the second one is whether it reduces the resources used in the computer. In the past, I've found that the Patent Office tends to consider a computer problem specifically as it relates to reducing the resources in a computer. So reducing processing power or increasing speed or whatever the case may be. Computer problem really seems to have been limited in the past to the actual resources of the computer. The fact that there are 2 separate tests here leads me to believe that maybe a computer problem can be defined a bit more broadly than it has been in the past. Maybe I'm being a little bit cautiously, I would say I'm being cautiously optimistic that there will be an improvement in the scope of what a computer problem is, but the proof is in the pudding, as they say. So moving on, example 1 is very similar to example 3, except it includes the additional step of performing seismic measurements. In the guidance, it suggests that this step is an essential step and it cooperates in combination with the processing steps of B and D to produce better results of using the algorithm. And since step A includes measurements that rely on discernible physical effects or change, it is sufficient to make the claim patent eligible subject matter. So simply performing seismic measurements is sufficient to overcome the patent eligibility hurdle. Similarly, in example 5, an additional step of drilling for oil rather than displaying the results on the computer is also sufficient to provide patent eligibility. The example states that step C cooperates in combination with the computer step B to produce better results from well drilling operation. So basically, initially when I read the guidance, I was a little concerned that the wording had simply just shifted and the objections we would receive would be the same. There seemed to be a lot of shuffling of the chairs on the deck of the Titanic, so to speak. After reviewing the examples, I was definitely a little bit more optimistic that we would be able to get some more claims through that we had been having issues with in the past. And anecdotally, specifically as it relates to oil and gas, we're definitely noticing an improvement in the prosecution of claims that do relate to detection of performing measurements or drilling. Those steps are now becoming sufficient to overcome any objections with regard to patent eligible subject matter. So there is definitely an effect that we're noticing already in view of this post-Shui guidance. But unfortunately, I haven't seen too many other cases yet coming across my desk. I have reviewed the Patent Office records, and there haven't been any real patent appeal board decisions that I have found that rely on the new guidance, obviously, except for the recent Shui Patent Appeal Board decision that was decided on January 11th of this year. And this decision was subsequent to the court's decision. And as a result of this decision, the second proposed claim set that was actually submitted that was previously submitted was found to be patent eligible subject matter. So what has changed? Why the change of heart? So just to give a little bit of background on Shui. The claimed invention relates to investment portfolio. Throughout the prosecution of the patent with the Patent Office, the Patent Office has defined the problem of reducing volatility of an investor's portfolio. The applicant came back and argued that yes, but this relates to portfolio engineering and is therefore technical subject matter. And the Patent Office came back and said, well, yes, portfolio engineering might be fine, but that is not technical. That relates to simple business methods and therefore is not patent eligible. However, the new claims that were found to be patent eligible were added shortly before the Patent Appeal Board hearing, and they included a step that recited a novel transformation that was used to convert data from a first form to a second form, so that the data could be optimized in that second form faster and using less processing power than prior art. Interestingly, the description doesn't mention this technical improvement at all. There's no discussion in the description of any technical improvement. However, the applicants did submit an affidavit supporting 50 to 200 times speed processing improvement of using this new transform as compared to prior art improvements. In this new decision, the Patent Appeal Board found that speed improvement was sufficient to make the computer an essential element of the claim and contribute to the actual invention, and therefore it was patent eligible subject matter. So how much has changed? So the problem solution approach, as mentioned before, has been replaced now with a determination of what the actual invention is. And as I mentioned, I was a little bit pessimistic initially. Maybe it's just years of abuse by the Patent Office with business method and patent, computer-related inventions. But after review of some of the examples and this new Shui decision, there may actually be some hope for getting some of these claims through. If the Patent Office can't arbitrarily determine what the problem and solution is, then they will have to analyze each of the elements of the claims, as we have been arguing, or most of us in the field have been arguing for many years, to try and get them to make a determination as to what the actual invention is, so to speak. The question is, will this be an objective or a subjective test? It's hard to know how the Patent Office is going to address this. A lot of the features were glossed over in the examples. The examples merely mention that elements do or do not contribute to the actual invention. They don't really discuss why. And this will likely be this is the likeliest point of contention between applicants and the Patent Office going forward, as I see it. Like I said, I'm cautiously optimistic at this point that it will not be too contentious, but there certainly is the possibility for contention, because once the actual invention has been determined, the rest is just simply rote. Another good thing is that the context invention is no longer an issue. As we mentioned in one of the examples, performing the measurement in the past would simply have been dismissed by the Patent Offices as context of the invention and not be considered when determining patent eligibility. That seems to be no longer an issue, and that should hopefully help overcome Section 2 objections for many applications. Similarly, post-solution activity may not be an issue. The step of adding drilling to a claim may help get things through, whereas in the past, steps like that were considered to be post-solution activity. So what can we do to try and position our applications to, as best as possible, to get them through the Patent Office in view of the new guidelines? The first step, obviously, is the simplest one. Unfortunately, it doesn't apply to every application, but wherever possible, try and frame the problem as a computer problem. If you can frame the problem as relating to the processing speed, processing power, data storage, or data security with the prior art, then it's highly unlikely that the Patent Office will even raise a Section 2 objection. And if they do, it should be pretty easy to overcome it. And if you can do that, then also provide a description that ties in the algorithm described in the application to solving that problem. The next step is a little bit more complicated, and I'm not entirely sure I understand where the Patent Office's position stands on these types of claims. But if you can provide details of the implementation and the description of the claims, then you put yourself in better stead to argue any Section 2 objections, even if you don't have a computer problem as framed above. So consider, for example, a case where you don't have a computer problem, but you don't have a computer problem in terms of processing speed, but you have a problem with the operation of the computer. So for example, consider a method for color matching. So if you're trying to solve the problem of selecting complementary colors on a computer, how do you do it? Most people would handle that problem manually. They look at two colors and determine that, oh, these two colors match or these two colors don't match. But a computer can't do that. And so describing and filing an application to a method for actually making this complementary color matching, the question is, does that relate to a computer problem? And so that's, I think, where things are a little bit ambiguous at the moment. But if you include details of the implementation and how the computer would actually implement that algorithm to solve the problem of color matching, then I think we have a better position. You're in a better position to argue that there is a computer problem there, and that it's not simply a matter of automating what was known in the art, which is where a lot of these claims may fail, because it's not acceptable simply to just automate known methods. But if you're creating a new method, then perhaps you have an opportunity to solve a computer problem that's not defined as described above. And then lastly, if possible, include features in the claims that have physical existence or affect a physical effect or change. And this, from the examples, would be the performance measurement or the drilling steps in the examples 3 and 5, or 1 and 5. And the one thing to be careful there, obviously, is that you don't want to put these steps in if it's going to be implemented by a second party. So if one party is performing the calculations, but a second party is actually doing the drilling, then you may run into issues if you're trying to go after somebody for infringement, if you don't have any potential direct infringement. So you know, as usual with patents, there's a balance between trying to get something through and making sure that you cover your invention as broadly as you can and get your client the most potential protection that they can. But at the same time, trying to make sure that you actually can get a patent issued for the technology. So these are just kind of things that you have to try to keep in mind when drafting claims and trying to overcome setting yourself up to be able to overcome any possible Section 2 objections by the Patent Office. Anyway, thanks very much. I'm going to hand off to my colleague James, who will talk about diagnostic methods, which I am definitely not qualified to discuss.
All right. Thanks, Jonathan. That was great. I want to thank everyone who stuck around for the diagnostic portion of the talk and powered through computer implemented inventions, which are not often something we're too familiar with on our side. So I will start up. So here we go. Diagnostic methods have had a tough path in Canada for a while now, and it's been difficult for patentees to obtain usable claims that they could implement. And the Shui case that came out last summer, and then the CIPO guidance that built on that, at least on the diagnostic method side, was very helpful, even though as Jonathan mentioned, the Shui case dealt with computer implemented inventions. So we're going to go over today how the new guidance has changed the picture in Canada, how we can better position our patent applications to get a usable claim scope, and the nuances of the changes and how to work with them. And I think the best way to start is to go over sort of where we were, so that we can understand what the problem was, and then how things have changed, so we can take advantage of the changes. First, a sample claim. These are sample claims that CIPO provided in their guidance, and we're going to use them sort of throughout my discussion here. So they're very similar claims. You can see it's a very typical method of diagnosing something. Claim 1, method of diagnosing whether a human subject is at risk of developing cancer. It includes 2 steps, the typical 2 steps. Measuring the level of something in a sample from the subject, and then comparing that level to the level of a non-cancerous reference sample or a baseline, wherein the increase in the level is relative to a reference indicates an issue. So, sorry, I just got a note that my volume's fading a bit. I'll try and speak a little closer to the microphone. And then you can see in claim 2, very similar claim, but the difference is that instead of measuring the level, you're actually just receiving the information regarding the data that's been collected. And so, although under our previous guidance, these 2 types of claims wouldn't have really had much of a difference, under the new guidance, you'll see that there's quite a difference that we'll need to keep in mind in order to get claims that you can use. So previously, basically, you would have seen that CIPO took the stance that these claims were comprised of 2 different components: the data acquisition step and the data analysis step. And whether that data acquisition step was a physical step of actually obtaining the information from the sample, or whether you were provided with that information, didn't really change how CIPO looked at the claim. Basically, if the data acquisition step was already known and wasn't new or inventive and didn't really form the inventive portion of what CIPO considered to be the invention, they would go through their claims construction and deem it unessential, and it would leave you with just the data analysis step. And once you're left with just the data analysis step, regardless of the complexity of the data analysis, how much work went into figuring out the correlation. They basically looked at it and said, all you're doing is comparing two different things, and that is a mere correlation of data, and it was deemed to be a disembodied mental conclusion or an abstract idea. And those types of disembodied conclusions and abstract ideas are not within our definition of invention under Section 2 of the Patent Act. And that hasn't changed. It's just how we're looking at them that's changed. And sort of how did we get there? Well, as Jonathan mentioned, SIPO was using a problem solution approach. We can go back and forth as to whether or not that was the right approach at the time and whether or not they were misinterpreting case law. And I think many practitioners would agree that they were, but it's not really helpful at this stage. So basically what they did is the MOPOP, which was our manual of patent office practice, provided the guidance as to how you would look at a diagnostic method claim or all claims and apply the problem solution approach. And as Jonathan touched on, it was the identification of the essential elements of a claim cannot be performed without having first properly identified the proposed solution to the disclosed problem. And that's where we start to implement that problem solution approach. SIPO took the position that the problem solution approach arose logically from purpose of claim construction, which they interpreted from the Supreme Court of Canada case that Jonathan touched on. And they didn't really get it right, but luckily we've had a correction now. And of course, the issue with SIPO approach is that it resulted in the omission of various steps that basically took away your opportunity to have a diagnostic method claim. And once you did that, you were left with very few options as to how to amend your claim to get an allowance with something. There are two obvious solutions: the Patent Appeal Board and appeal to the federal court, which is exactly what the Shui case is an example of. But those are time-consuming, costly, and you simply don't know what the outcome is going to be. So you were left with basically the option of arguing against the rejection based on case law, and we would cite often the Free World Trust case and the Whirlpool case, but to no end. Then you would amend your claim to try and find some sort of active step that you could implement following the diagnosis. The problem with that in Canada is that in order to take an active step, you're going to need supporting data that shows that active step had utility, and you cannot rely on post-filing data in Canada. And the result is either you add that step and it gets shot down as being new matter, or you've also now limited your claim to a scope that might not have any value to the patentee. And as Jonathan touched on as well, if it is now being carried out by 2 or 3 different entities, how do you capture someone as an infringer once you've included these steps? So we were in quite a bind trying to get a diagnostic method claim that didn't have an active step at the end, and that was supported by the application. So that brings us to the Shui case that came out last summer, which was an appeal decision of the Commissioner of Patents refusal. Basically, as Jonathan touched on, SIPO took the position that the problem solution approach was the correct approach. They said that it arose logically from purpose of claim construction, and submitted that as the purpose of a claimed invention is to provide an operable solution to a practical problem, purpose of claim construction resulted in the determination of essential elements and necessarily informed by its disclosure of the problem and solution. So Shui took the opposite position, keeping in mind that the free will trust case, it made you have to consider the intent of the inventor and what was actually invented. And basically the problem solution approach omitted the first step of really thinking about what the inventor actually invented and what their intent for the invention was. Basically, they argued that an element may be found to be essential on the basis of the intent of the inventor as expressed or inferred from the claims, or on the basis of evidence as to whether it would have been obvious to a skilled worker at the time the patent was published that a variant of a particular element would make a difference. They also pointed to another case that Free World Trust also mentioned, and that is the principle that everything in a claim is presumed to be essential unless it's established otherwise. And I think we've all operated on that basis as practitioners, that anything that's in a claim is essential. Otherwise, why do you have it in there? Now, luckily, the courts found that the problem solution approach was incorrect. They relied on the Free World Trust case. They relied on findings in the Shire case. And basically, as I mentioned, that in order to establish that a claim element is non-essential, it must show both that on a claims construction of the words in the claim, it was clearly not intended to be essential. And that's the key. I think that's what SIPO was overlooking before when they were carrying out their claims construction. And so we were able to get rid of the problem solution approach. And really, from the diagnostic methods point of view, what was helpful, much more helpful, is the new guidance that SIPO came out with in November. And basically, I would say that the Shui case, because it's not related specifically to diagnostic methods, it was helpful in shooting down the problem solution approach, but really what's helpful for patentees with respect to diagnostic methods is the guidance that SIPO came out with. I think they got it mostly right. I don't, there's still some issues, and we'll touch on them a little bit, but really they've given us some relatively clear guidance in what to do, how to obtain a claim. And I think that for most patentees, it's going to be helpful, as you'll see here. So basically they said, as with any other claim, all the elements set out in a medical diagnostic method claim are presumed essential, unless it's established otherwise or is contrary to the language of the claim. So that's consistent with our case law. An abstract idea, that's an element of a claim that cooperates with other elements of the claim, must be becomes part of a combination of elements making up a single invention. And we're going to break down a claim, and we'll see how that combination can result in statutory subject matter. And basically resulted in their conclusion that a diagnostic method claim that defines a combination of elements that cooperates together so as to form a single actual invention that includes the physical means for testing, identifying and detecting, and then the presence of an analyte or of data is considered patentable subject matter and is not prohibited. So let's go back to those sample claims. As we touched on, the first claim includes that physical step of measuring the level of a biomarker, a characteristic in the sample, and then comparing it. Whereas the second claim substitutes that step of measuring with a step of simply receiving the data. And there's going to be that difference is going to result in a significant difference on how SIPO will interpret that claim. And one is going to be found to be allowable and one will not be. And so that is where we really need to focus our attention on whether or not SIPO was correct in making that assumption isn't really up for debate in this talk. What we really want to talk about is how to take advantage of this new guidance to get everyone a claim that they can use. So breaking down that first claim, basically into the measuring element, the comparing element, and the correlation element, you see that you measure the level of the characteristic in the sample. There's your physicality or your physical component of the claim that, according to SIPO, brings you into patentability. It gets you patentability. And then you have your comparison, and then the correlation of that comparison to obtain the diagnosis. Step B, taken in isolation, would still be considered to be just a correlation. So you would go back to your abstract idea and your disembodied thought, and you wouldn't meet your requirements under Section 2. But when you include the step of the measuring element, then you get that cooperation that the guidance has indicated is allowable, and that type of claim would be allowable under the new guidance. Now, the new guidance came out in November. I have argued a number of times now on the basis of the new guidance for claims that are very similar in structure to this. We haven't had feedback yet, but I guess Jonathan said I am cautiously optimistic that it should work. And I suspect we'll find out in the next couple of months. But I mean, it's very clear in their guidance that that should work. Now, moving on to the other claim, I think everyone can sort of see what I'm getting at here. Very similar claim, but instead of doing the measuring, you are now receiving a report that summarizes the level of the characteristic in the sample. And because there's no physicality or physical step that's been carried out, at least in the claim, this type of claim would not be considered to be patentable subject matter, which, I mean, I think some people are going to have an issue with that, in that, I mean, the determination of the correlation and comparing it to the baseline, figuring out what's important in the baseline. To me, those are all inventive things that you know, someone has determined, but the SIPO will not take that position. So we need to obviously be very careful about how we word our steps. We need to take that into consideration as we develop the diagnostic method. And just keep that in the back of our mind as we're drafting patent applications and claim sets, to make sure that it's quite clear that the data is being collected by the user, and to make sure that we can draft a claim that SIPO is going to find allowable. So how best to position your Canadian claim set? As we touched on, the key is making sure that it includes the feature that the data is collected and measured. However you're doing it, so long as you're not simply receiving the information, make sure it's in the claim. And then there's a bunch of other things that we can rely on that Canada offers to make sure your claim set is complete as possible. The first one is no excess claim fees. And as you can see, it's the only tax break that Canada offers. I can confirm that. Will it last forever? Who knows? But there's no excess claim fees, and there's no fee associated with multiply dependent claims. So you know, take advantage of that. Have as many claims in your application as you can. Have independent claims that are directed to narrow embodiments or commercially important embodiments, specific diagnostic method criteria that you may think aren't that important in the grand scheme of things. Put them in an independent claim. There's absolutely no harm in Canada of doing that. You can use multiple types of claims, methods, uses, EPC 2000s, commercial package claims. Put all of them in there. Canada's rules regarding divisional applications are important to keep in mind. Our test for unity is pretty broad. So often you will not get unity rejections in Canada where you would often see them in other jurisdictions. And so keeping all of that together in the same case is cost effective, and it gives you a claim scope that is usable and valuable. The other thing to keep in mind with respect to divisionals in Canada is that our double patenting regulations are pretty strict. You must have the claims of the divisional have to be patentably distinct from the claims of the parent in order to be allowable. And often, I mean, we typically advise that you should not file a divisional application unless you've obtained a unity rejection, just to make sure that the office is taking the stance that it's a separate invention. Otherwise, you could run into double patenting problems. So take advantage of that. One issue you may run into is if you use the patent prosecution highway to expedite prosecution in Canada, you could run into a situation where you obtained your claims in the US, and those are the claims you want to use in Canada. But when you obtained your claims in the US, you took advantage of the continuation practice and obtained a narrower claim scope and then filed a continuation. If you then took that strategy in Canada, you'd get your expedited prosecution based on those narrow claims, but it wouldn't allow you to file a divisional application for the broader claim scope. So please keep that in mind in Canada. And of course, you can always reach out to me if you have a concern or want to discuss strategy. The other thing to keep in mind is for those cases where maybe you didn't enter the national phase in Canada because of our strict diagnostic method practice, you can still enter late for PCT applications that were filed before October 30, 2019. You can enter up to 42 months instead of 30. We all, as well, I'll just remind everybody that we have a 12-month grace period on disclosures. So for any of those particular cases where you thought maybe it's been disclosed, I can't file, or you thought Canada's diagnostic method practice was restrictive, you can change your mind now and we can help you out. So plenty of opportunity now to take advantage of the new regulations and CIPO's new guidance. So I will, that's sort of it for my portion. Happy to take questions now. I think Jonathan and I are ready for questions.
Okay, thanks so much, Jonathan and James, for that. We do have a couple of questions for you. One, we often wait for issuance of foreign counterparts before prosecuting the Canadian patent application. How would issuance of foreign corresponding patents be viewed in Canada under the new guidance?
I can take this one. The Canadian Patent Office will usually look favorably to foreign prosecution when it comes to prior art. Unfortunately, for patent eligibility, it doesn't always carry much weight. So the Patent Office will follow its own path when it comes to questions of patent eligibility.
Yeah, I think on the diagnostic method side, very similar. Foreign prosecution is going to be taken into consideration by every examiner in Canada, and definitely from a prior art point of view, but not from a eligible subject matter point of view.
Okay, and then how would that come into play then, James? You talked about PPH. So just a small question here about if they went ahead and used the PPH, how would that impact Canadian prosecution?
Sure. I mean, PPH is useful if you are satisfied with the claims that you obtained in the foreign jurisdiction, and obviously you are if you're wanting to use it. The biggest issue I see with PPH is just people running into the double patenting problem. So, you've obtained narrow claim scope. You now want to obtain broader claim scope. But that strategy isn't sort of, verbalized at the time we request PPH. And so we don't know that you might want to file a voluntary divisional down the road. and then our hands are kind of tied. So I would just say a couple things. One, keep in mind, sort of review the entire portfolio and figure out where you want to end up before you request PPH. If you have a doubt, obviously reach out to us and we can chat about it. And then with respect to the actual claim itself that you want to get allowed, one, make sure there's that physical step of carrying out the collection of data. And two, make sure there's support for it. But I think keep in mind that even though you request PPH, the Canadian examiner is still going to apply the Canadian guidance for statutory subject matter. It'll be helpful from the art point of view, but it's not going to be helpful from the statutory subject matter point of view. It won't be a simple rubber stamp of allowance.
And so just to, if you don't mind me jumping in here, James, just to supplement that. So PPH really is just patent prosecution highway. It advances the examination. It doesn't really obligate the examiner to allow the application. It just means that they're going to advance it. So what will happen is you'll get expedited prosecution, and likely, if it falls into the non-patent eligible subject matter, then you'll just have faster examination to an objection than if you had not requested patent prosecution highway. So for PPH cases that are borderline on patent eligible subject matter, it may be worth considering not filing them, but until cases are settled. But if it falls clearly within some of the allowed cases, then certainly go ahead and request a PPH. The other thing, what we have done, as James mentioned, in terms of if you have continuations in the US where you have different scopes of claims, and some of them are still pending and have not yet issued, so you can't do a PPH on all three or multiple applications. What we've done in the past is get the expedited prosecution, get the notice of allowance, and then what you can do is withdraw the notice of allowance and file an amended claim set. It costs a little bit more, but at least that will get the new claims on file with the patent office and it'll achieve the goal of expediting examination. So if your goal is to expedite examination, the PPH can still be used. You just have to have a couple tricks up your sleeve and just be aware before you pay that final fee that you do have other claims that you want to add. Because once you pay the fee, then you may be in trouble.
That's a good point, Jonathan. Actually, and the other thing about PPH, what you should keep in mind is the PPH can be a request based on multiple foreign applications. So if you do have your allowed parent, your allowed continuation, you can amend the claims in Canada for the PPH request to include both sets of allowed or issued claims from the US. So you can still get PPH on the whole family in a single application.
Yeah, I think that's really, I think those are very fair answers. I think the broad point is that, we have a lot of options still available to us, and we have a lot of ways to strategize, different ways of trying to make sure the Canadian prosecution is in the best interest and we're maximizing our options. There is one other question. We had to abandon some applications related to diagnostic methods in Canada. What are the options to reopen prosecution and try again under the new guidance? James.
Yeah, great question. It is our reinstatement rules with respect to abandonments as a result of failing to respond to an action have not changed. We still have 12 months to reinstate from the date of abandonment, and absolutely no problem. It's a reinstatement is a matter of right, so we can reinstate, submit arguments based on the new guidance, and fully within your rights.
Yeah, I know the question was related to diagnostic methods specifically, but Jonathan, do you have anything you want to add with a perspective from computer implemented?
No, the mechanics are pretty much the same regardless of the area of expertise. Just keep in mind to stay on top of your maintenance fees because those rules have changed a little bit. But yeah, other than that, if you've got an application that's abandoned for failing to respond to an office action, then yeah, you do have 12 months to reinstate as of right.
Yeah, perfect. Well, that pretty much gets us close to the end of our time. Thank you for joining us, everybody. We really appreciate it. And if you still have questions or we weren't able to get to your question, please feel free to reach out to anybody, and we'll always be happy to help you out. I do want to just remind you that MNC Canada is celebrating its 100 years of operation, and we do have a number of events lined up for the year. So keep an eye out on your email and LinkedIn and our website for upcoming events. We are planning a trademarks webinar for February. So keep an eye out for that. And we hope to see you all again for another event sometime soon. Thanks very much.